Hi, I'm immigration attorney Heather Poole. Today I'm speaking to you about the common mistakes made in unlawful presence waiver cases, which are also known as the 3 and 10-year bars. For a description of what the 3 and 10-year bar unlawful presence waiver is, or why you would need one, watch our video entitled 3 and 10-year bars for more information. Remember to always consult a competent, licensed immigration attorney before filing any relief, and if you're in this situation. Mistake number 1, not being eligible for the waiver to begin with. The waiver of the unlawful presence bars requires that an immigrant have either a U.S. citizen or permanent resident spouse or parent. I've seen many denials from other notaries and attorneys where they try to argue the hardship to a U.S. citizen child. A U.S. citizen child is not a qualifying relative for purposes of the waiver. CIS will not take their hardship into account. Many people are not eligible for the waiver because they have not claimed extreme hardship if they are separated from their spouse or parent, merely writing a letter explaining why they would miss their spouse. This is not hardship. This leads us to mistake number 2, not adequately documenting the hardship. The immigrant has to prove that the U.S. citizen or permanent resident spouse or parent in the United States would suffer extreme hardship if the immigrant was not allowed to return within 3 or 10 years that they are barred for. Hardship is something that's not easily defined under the law. Documentation of more than just separation from a loved one that may cause emotional damage or financial hardship or financial loss is not enough. To CIS, they believe these kinds of struggles are common to any sort of separation from a loved one that results from a removal or deportation. Failing to make your case stand apart from everyone else's in the same situation is a major mistake and can make you ineligible for the waiver. The hardship must be connected to the qualifying relative directly, not to another family member. You must focus on the relative by which the immigrant qualifies for the waiver. So if they're basing the waiver based on their spouse, the hardship argument should go directly towards the spouse. I've seen many bad psychological evaluations, doctor's evidence, even country condition evidence, online depression and personality tests that do more harm than good to show hardship. These are usually not the best form of extreme hardship evidence. Be very careful in reviewing closely what you submit as evidence of hardship. Do not copy someone else's hardship letter or arguments that you may have found on the internet. Documentation from the internet is reviewable by CIS as well, and likely they have seen it before. Mistake number 3, leaving the U.S. to apply for the waiver when you don't have to leave the U.S. in the first place. If you enter the U.S. legally and can prove that you entered the U.S. legally, but still have your I-94 card, the white card that gives you the amount of time you're allowed to stay under your visa, and if you are married to a U.S. citizen, even if you overstay that I-94 card period, and you can still prove that you have it, you are eligible to apply for a green card in the United States without leaving. This is crucial because the 3 and 10-year bar of unlawful presence is not triggered until you actually depart the United States. So if you never depart, you should be able to adjust, assuming there are no other grounds as to why you can't get a green card. As long as you have not entered the United States illegally or have a prior removal order, any overstay of an existing visa, if you're married to a U.S. citizen, will be forgivable. One of the toughest cases I had for a 10-year bar waiver involved a spouse who listened to friends of theirs who had not been subject to the 10-year bar, but had told them that the immigrant had to travel abroad to get the green card based on the marriage. Only when she was at the consulate for the interview was she told that she had accrued the 10-year bar because of her year or more that she overstayed her visa in the United States. If she had just talked to a competent immigration attorney before she left, she would have been able to save herself a lot of separation time from her loved one, from her spouse, and a lot of money from hiring an attorney having to do a waiver case. She never would have had to file. There may even be options for those people who have entered the United States illegally. They may benefit from INA Section 245I, which was part of the law that was in effect April 30th, 2001, that allowed people who entered illegally to obtain a green card despite the illegal entry if they had a family-based immigrant visa employment visa, or labor certification filed by an employer by the cutoff date. Even if there was no application directly filed for the immigrant, if the immigrant's parent or spouse had an application filed for them by this cutoff date, the immigrant may be able to grandfather and attach to the previous filing and get to apply for a green card in the United States based on a new petition, even though they entered illegally. This is a very complicated area of the law, but it does show that there may be options to you. So the general rule is, do not leave the country until talking to an immigration attorney first. You always want to get your green card in the United States if you can help it. There may be other alternatives for you that are not discussed in this video. If you need my help, feel free to call us or contact us through our website, humanrightsattorney.com. Thank you and good luck.